Sir.
No, we're done. You've had every opportunity to speak, and now it's my turn to speak. Iowa President 23 CR 630, State of Ohio versus William Johnson III. We're here for a final hearing on the state's motion to terminate community control sanctions. The defendant previously waived probable cause. And as I said, we're here for the final hearing. Defendant's in court with counsel, Mr. Chad Mulkey. Mr. Mulkey, what's the defendant's intention at this time regarding the final hearing?
Your Honor, after conferencing with my client, his intention for this final hearing is to waive that hearing and enter a plea of guilty to the probation violations. Thank you.
So Johnson, you've been charged with violating the conditions of your community control sanctions. Specifically, it is alleged that you violated two separate violations, both the same rule. Rule 8, which prohibits you from using, possessing, or having under your control any controlled substance not prescribed to you by a licensed physician. It's alleged, first off, that on November 20th, you submitted a urine sample that tested positive for cocaine. It's then alleged that on December 4th, you submitted a urine sample that tested positive for cocaine. Now, you have the right to have final hearing regarding these allegations, which is a hearing where the state would be required to prove the actual merits of what they're alleging. You can have this hearing, but you can also waive the hearing if you desire and plead guilty to the violations. Your lawyer has indicated he believes that's what you want to do, waive the hearing and plead guilty. Is that correct?
That's correct, Your Honor.
Well, before I can accept your waiver and your admission, I need to make sure you understand the potential penalties you face if you're found to be in violation of your community control sanctions. If in fact that did occur, the court could extend your probation up to 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. And if I did that, it could be 9, 12, 18, 24, 30, or 36 months in prison. Do you understand all the potential penalties you face if you're found to have violated your community control sanctions?
Yes, Your Honor.
Well, having been so advised, what do you want to do at this time? Do you want to have the final hearing, or do you want to waive the hearing and plead guilty to the violation?
I'll waive the hearing and plead guilty, sir.
Very well. That's the allegation that you violated Rule 8. Hang on a second. That you violated Rule 8 by submitting a urine sample on November 20th that tested positive for cocaine. What is your plea to that?
Guilty.
As to the Rule 8 violation that you submitted a urine sample on December 4th that tested positive for cocaine, what is your plea to that?
Guilty.
All right, the court will accept your pleas of guilty, find that you did violate your community control sanctions. Mr. Mulkey, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Yes, Your Honor. My client would ask this court to extend his community control. He acknowledged that he does have a cocaine use problem, Your Honor, to that end.
He does? When did he do that?
He did at least today, Your Honor, to me. And the reason that I say that also is I was in contact with a person that he knows, I believe it's his girlfriend, Antoinette. Yesterday, she had me reach out to Olympic Grove, which is a detox facility located in Euclid. They have a 30-day detox program. It's not a lockdown facility, but they indicated a willingness to help him. I told them about his most recent positive test. They said that's not a bar to him going into that program if he's willing and able to do that. He indicated to me that he is willing and able to do that. I know NeoCap had been discussed, and he was assessed for NeoCap, Your Honor. So regardless of the court's decision, I would ask that that decision include an extension of his community control. He understands that he is looking at prison in this matter for these tests, but he would like to get his drug use under control, at least at this point in time. I know on prior occasions he's had some difficulty coming to terms with that admission, Your Honor, but as recently as this morning, he indicated a realization of his cocaine use and a desire to make a positive change in his life to that effect, Your Honor. Thank you.
At this point, the court is being asked to extend trust that has already been tested. Treatment is available, but availability isn't the issue here. Credibility is. Probation only works when a defendant acknowledges the behavior it's meant to control. Without a clear admission and consistent compliance, the court has to decide whether continued supervision still serves any purpose at all.
Mr. Johnson, you have the right to address this court before your sentence. You can say anything you want. Is there anything you want to say at this time?
Yes, Your Honor. After speaking with the program of Olympic, they informed me that it would help me push on with further things in my life that I was trying to do. Like they was going to give me access to the VA benefits I've been trying to do. They're going to help me with my driver's license, and they're going to help me with housing, which is one of the reasons why I'm having an issue with this cocaine issue, is because I need to change my environment. And I believe that the Olympic will help me change my environment, get me out of the situation that I'm in, and I should have no further problems with this at all, Your Honor.
Problems with what? You've never admitted you have a problem with cocaine. You always blamed it on your girlfriend that she uses and you get it from her somehow. Miraculously gets transferred to you. In fact, just as recent as, when was his interview with NeoCap?
Yesterday.
Yesterday, you met with people from NeoCap. I got no problem with cocaine. I use cocaine.
Okay, that's what I'm trying to say, sir.
Yeah, what are you trying to say?
I'm trying to change my environment.
All right.
If possible, I was hoping that I could take this program.
For what? What do you need a program for?
The program was going to help me with the other things that I need help with. It was going to push me forward, with helping with my business. And
what problem?
Well, my problem is I'm in love, you know what I'm saying? And I'm just trying to stay away
I
from
know.
it.
All right, say whatever you want. Anything else you want to say?
Would you please consider the program, Your Honor?
Mr. Mulkey, anything else?
No, Your Honor.
This
Thank you.
court reviewed the pre-sentence report and investigation. I've considered the facts and circumstances of the underlying offense, the nature of the offense. I've considered defendant's performance on probation, the history of these violations. I've considered what's been said here today. All of this is considered under the purposes and principles of felony sentencing set forth in 29-29-11. For the factors in 29-29-12, I'll incorporate all the findings I've made throughout the case regarding the seriousness factors and the recidivism factors, with the additional finding today that the defendant has, once again, failed to comply with the previously imposed sanctions ordered by this court, which is a factor indicating recidivism is more likely. You know, Mr. Johnson, this is your history here. At the time of the plea, you went to probation department, you tested positive for marijuana. Put you on probation. You tested positive for marijuana. We gave you a review board contract. We didn't violate you. We gave you a review board contract. This past summer, then, you tested positive for cocaine. You got violated. And I ordered that you get counseling at more counseling. Since then, you've tested positive for cocaine at more counseling. You've tested positive twice here over 2 different weeks, so it's not the same violation or use for cocaine. But you do not acknowledge that you have any problem with cocaine. You say you don't use cocaine. You couldn't even say it here today.
Yes, sir.
No, we're done. You've had every opportunity to speak, and now it's my turn to speak. You met someone yesterday, NeoCap, to try to get into a program. You said, I don't have a problem with cocaine. I don't use cocaine. I get it from my girlfriend. The positive screen you pick up from your girlfriend somehow. Gave you an opportunity this morning to talk about that. You talk about it's going to help me with my problems, but I don't know what problems you have. You don't say anything. You just say my environment. So it's clear that we've given you multiple opportunities. You won't acknowledge that you have any problem with cocaine. That's going to continue. So you're not amenable to any available community control sanctions at this point. Prison is consistent with the purposes and principles of sentencing. Therefore, this court terminates the defendant's period of community control sanction. That sentences the defendant to 12 months in prison. He has credit for 120 days he's already served. We need to advise you upon your release. You may be placed on post-release control for up to 2 years. If you are and you're violating those conditions, the parole authority can return you to prison as punishment for violating their rules for another 6 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control, and the defendant's ordered to pay all costs. Mr. Mulkey, is there anything else for the record?
No, Your Honor.
This case ended where many probation matters do, not because help was unavailable, but because credibility had eroded. The defendant admitted to multiple violations involving cocaine use and waived his right to a contested hearing. Despite repeated opportunities for treatment and supervision, the court found a pattern of non-compliance and shifting explanations rather than accountability. The judge focused less on the existence of programs and more on the defendant's unwillingness to clearly acknowledge the problem those programs were meant to address. Prior leniency, counseling, and review contracts failed to change behavior, and continued violations signaled that community control no longer served its purpose. As a result, probation was terminated and a 12-month prison sentence imposed, with credit for time already served. The ruling reflects a core principle of supervision. Treatment can supplement accountability, but it cannot replace it. When conditions are repeatedly violated, the court's responsibility shifts from rehabilitation to enforcement.